Well, I may well start now because I can see that the number of attendees joining us has stopped. We may have others coming in a moment, but let's get going. So welcome to everybody. My name is David Gardner from Number 5 Chambers and the SWALA Secretary. And can I welcome you all to this Southwest Administrative Lawyers event on the NHS, our NHS webinar. And I'm very pleased to welcome you all to join us. It's often for me as chair to deal with the housekeeping issues at the outset. In these formats, it's slightly different, of course. If you need the facilities, you're in your own home, you know where they are. If you hear a fire alarm, it's got a test, there's a fire in your house, and you may well need to leave very quickly. But I shall refine my comments now to simply saying, as a member of SWALA, can I, at the outset, as I say, welcome you, but also invite you to start following us on Twitter. So we are on Twitter at SWALA. Can I invite you also to contact either Guy or I so that you can be informed about future events if you're not already on our mailing list. And can I also ask you to, when this webinar is over and you receive an email from us, which has a link both to a survey prepared by SWALA and a feedback link prepared by St John's Chambers, I invite you to please respond to that. Hopefully it shouldn't take you too long. We have some excellent speakers for you tonight, and I'll go on to introduce them in a moment. But can I also ask that when we deal with the Q&A at the end, that you use the Q&A box in Zoom, and I'll be able to moderate those questions, and hopefully we'll have some interesting discussion at the end. I hope you will agree with me in saying it's quite a pertinent time for an NHS webinar. Certainly during a pandemic, we can all be appreciative of quite the work the NHS does for everybody. I'm sure the whole country extends a great thanks to certainly the front line, but everybody who works in the NHS. But of course, as public lawyers, our ears prick up at various different topics that arise relating to the NHS. Certainly when you hear stories of the numbers of cases that may be flooding hospitals, and there may need to be some kind of system whereby we choose who receives services. As a public lawyer, your ears prick up. When you hear reports in the media of government contracts worth millions going not necessarily in terms of merits, but in terms of potential nepotism, then of course, as public lawyers, our ears prick up. I say nothing to the veracity of those comments, of course, but of course, it is something that we all wish to have an interest in, and as lawyers, we may wish to litigate upon. And I'm very grateful to be able to introduce to you our fantastic speakers for this evening. Our first speaker is going to be David Locke. Our second speaker is Laura Brealey, and our third speaker is Guy Adams. Now, we're very, very grateful to David for joining us this evening. David is going to speak to us upon rationing NHS services in a pandemic. And he, if you are a public lawyer as I, will be no stranger to you. And his name is well known across public law in England and Wales. He's a QC, having been called to the bar in 1985 and made a QC in 2011. He's a public law specialist, as you may well know, and indeed Legal 500 named him as Public Law QC of the Year this year. He sits as a Deputy High Court Judge and has appeared at all levels in all courts in this country. And I think certainly his Legal 500 entry which suggests he's exceptionally knowledgeable and gains the confidence of vulnerable clients is a particularly apt way to introduce him. And so in a moment, I'll ask him to take the first speaker's chair. Our second speaker after David, and David will hand over to her, is Laura Brealey. Laura is a partner at Bevan, Brittan, and Laura has a particular interest and specialism in public procurement law. She also deals with a number of judicial reviews relating to public procurement. And she's been involved in a number of dispute resolution exercises as well, including interim relief negotiation and mediation. Her extensive practice in those areas, I'm sure, is well known to many of our attendees. And finally, we have Guy Adams. Guy, a member of St John's Chambers, and has a wonderful and long list of areas of expertise, and he's certainly an expert in all of them: administrative law, agriculture and rural affairs, commercial, professional negligence, real estate, wills and trust. And one thing I will say in terms of Guy's practice, not just extensive, and I could go through a number of different Chambers UK recommendations for him, but Guy is also the chair of SWALA, and I think it should be recognised by everybody, me included, just quite what an impact Guy has had on administrative law in the Southwest. Indeed, he was the inaugural chair of our informal association, and I'm sure we wouldn't be going today without him. So I pass on my thanks personally in any event at this stage. I think that's probably enough from me. I've gone slightly over my 5 minutes in my introduction. So if I may, I'm going to pass on to David Locke to speak to us first. Thank you.
Thank you very much, David, for that very kind introduction. Ladies and gentlemen, I've been asked to speak on rationing NHS services in a pandemic, and I sort of feel that this is a bit like going on to Mastermind and being asked for your specialist subject. Over the last 6 months, I've been asked to advise so many times on this that it's clearly an issue which is being of concern to a large number of people in the NHS and who use NHS services. And the nature of the pandemic, it seems to me, is that either you're working for the NHS, as indeed my sort of wife as a doctor and my daughter as a doctor are, alternatively, you're in the other category, which is that we're using NHS services, in which case this is an issue which sort of affects everybody. I'm going to talk only for about 20 minutes, so I'm afraid I'm going to scratch the surface. The first point, though, to make is to look at the background. The NHS rations services. It's often very reluctant to say it rations services, but it does, and it has done so since the commencement of the NHS. It is an inevitable feature of a tax-funded and therefore resource-limited healthcare system that it cannot provide enough healthcare to meet demand. Never has done, never will do, and there are all sorts of reasons for that, part of which is that the more health services you provide, the more demand you create. So the idea of being able to provide a comprehensive healthcare system which meets everybody's needs is a pipe dream, it's unreality. But it's worth reflecting that rationing of healthcare is true for every single healthcare system throughout the world. There's rationing in private insurance-based systems because either the treatment that you want is on the list that you provide for in the schedule at the back of your insurance policy, or it isn't. And if it isn't, you don't get the treatment. And anyone who's struggled with healthcare in America will know that the first question is whether you've got healthcare insurance. And the second question is whether the healthcare insurance you've got covers whatever treatment you want. If it doesn't, you're not treated, or you're not treated unless you pay. The same is true for public insurance systems. So in Canada or in France, you have exactly the same system. The limitations are wider or narrower depending on what decisions are taken by society generally, by politicians on our behalf, as to how much money they want to put into healthcare. But the fact of rationing, however wide or narrow the scheme is, still exists because it's simply a recognition that there are boundaries. And then, of course, there is the whole of the developed world where there's a very large amount of rationing, self-rationing by self-payment. People don't access healthcare that they can't afford to, and that's a form of rationing. But also we need to bear in mind when looking particularly in the present pandemic that we're not just rationed by financial demands. They're rationing by resource demands as well. There are only so many ICU beds. There's only so much specialist equipment in any hospital. There are only so many dialysis machines, and there are only so many organs available for transplant. And all of those in one way or another are rationing issues. So the first question is, as lawyers, is rationing in the NHS lawful? And the answer is that it is clearly both lawful and inevitable. The Secretary of State has a duty under Section 1 of the NHS Act 2006, which of course is a consolidating statute, which replaced the NHS Act 1977, which in turn replaced the NHS Act 1948. And the duty is to promote a comprehensive healthcare service. But as the famous case of Coughlin decided, a Southwest case, it's a duty to promote, not a duty to provide. And therefore, as long as the Secretary of State remains focused on the possibility of promotion of a comprehensive healthcare system, even if that is something he will never actually achieve, he's not in breach of the duty. Rationing is not a breach of the European Convention of Human Rights. It's not unlawful. The famous case of Jamie Bowen, the Crown against Cambridge Health Authority ex parte B in 1995, or the Condliffe case, Condliffe versus Staffordshire PCT, which I did for the NHS in 2012. And that case decided that ECHR rights are not even engaged in rationing decisions. It's because what is hurting people is the underlying medical condition. The allocation of resources by a state to treating healthcare conditions doesn't fall within the positive duty under Article 8, slightly revised in Tracy and Cambridge University Trust, but in principle, a very narrow possibility of raising ECHR points. And also rationing is lawful because doctors, while they have duties to individual patients, they also have duties to patients generally. So there is as much duty to the next person to occupy an ICU bed as there is to the present occupant. And that's an important part of the professional framework, which will come in a bit later. Rationing has also been considered in terms of issues not just in terms of money. So rationing of donated organs is held to be lawful because under the Secretary of State's directions, there's a preference for donated organs for UK residents. And the legality of that was tested in the BA case and found to be lawful. There's also an interesting recent case about the rationing in effect of hospital bed occupancy, where Mr. Justice Chamberlain was confronted with this issue in University College Hospital's case, and very clearly decided that the same approach should be taken to the rationing of hospital beds and the occupation of hospital beds as all other aspects of rationing. And the principle is that the NHS works on a utilitarian basis. The limited resources have to be allocated to the maximum advantage of the maximum number of patients. And that's a quotation which comes from Cambridge University's Hospital ex parte B, Cambridge Health Authority ex parte B, from the late Lord Bingham, or Lord Justice Bingham as he then was. And it encompasses the problem that demand exceeds supply, and therefore those having to make allocation decisions have to make impossible decisions, and those are decisions for administrators. They're not decisions for the courts, and therefore they can only be challenged in the courts on extremely narrow grounds. So what are the sources of guidance for decision makers in the current pandemic, where quite frequently demand will exceed supply? And in these circumstances, this will come up in a number of ways, but in particular, there are likely to be, there have been and will be problems about ICU beds, intensive care unit beds. How do doctors in ICU decisions make decisions lawfully and rationally when there are patients, when ICU is full and there's a queue at the door? Now, we know that there was Department of Health guidance prepared, draft guidance, Indeed, I know people who were on the committee that prepared the guidance. But the government took the decision in April not to publish the guidance. And that's a fascinating decision, the politics of which I can't pretend to understand. But I think the government did not want to admit of the possibility that rationing would occur, which may lead to people dying, because they didn't want to admit that the NHS would not be able to cope. But in fact, the early decision to clear hospitals of particularly elderly patients who were then taken to care homes in March of this year was a classic rationing decision, because they were clearing the hospital beds in order for the influx of COVID patients. And as a result, passed an awful lot of COVID infected elderly people out of hospital, who then spread the infections in care homes. And that was a rationing decision. Whether it was a lawful one or not lawful one will have to be seen, but permission has been given in the judicial review. There is a judicial review, I'm not involved in it, proceeding at the moment about the legality of the government's decision not to publish the guidance. It'll be very interesting to see whether that gets anywhere. But there is some guidance out there. I have the privilege of sitting and have sat for a number of years as a member of the BMA Ethics Committee, because the BMA is a trade union for doctors. And that trade union has published guidance. So it's non-statutory guidance. It's not even Royal College guidance. But in a number of areas, the BMA's guidance is treated by the courts with considerable respect. And it's generally been welcomed as practical, sensible, and informed guidance. And what it essentially says is that doctors have to make clinical decisions as to how to use resources in the best way, and that both in terms of whether to treat and whether to continue to treat, doctors are entitled and indeed obliged by their professional duties to take rationing decisions. I was part of the committee that produced that guidance, and I was pleased to see that it was generally accepted. It has had some academic criticism. It was described as a brutally utilitarian ethical approach, which seems to cut across the fundamental values of English medical law in one article, which I was amused to read. The problem with that approach, though, is that it seeks to give priority to the treated patient over the untreated patient. And that seems to me to be ethically problematic, but not a proper approach in law. I don't see why someone gets priority merely because they turned up at the ICU 10 minutes earlier. What's the critical issue? There's obviously issues about rationing, in particular, the question of who gets, for example, access to respirators. Though I understand that as much the problem is now dialysis machines as respirators. But the issue that troubled the BMA committee most was whether it was ethical and indeed lawful to withdraw ICU treatment from a stable but not improving patient but who might die without ICU support, in order to give one or more other patients a chance of recovery. And this is a real problem in practice, because someone can be held stable in ICU for 40, 50, 60 days. But in a time when there is enormous pressure on those facilities, is it lawful to say to somebody, well, our practice is to give you 14 days on ICU or 10 days on ICU, and if you don't recover in that time, then that facility is made available to others if there's a queue of people who might turn around in 7 days on ICU, and then the next person comes in and uses the ICU bed, and the next. And so the price that you pay for one person having their life maintained on ICU is that 3 others die. Now, that's a really difficult question, because it's about, can the NHS lawfully impose time limits on limited ICU facilities? And the answer must be yes. And arguably, it would be unfair, unethical, possibly even unlawful to the waiting patients who have a better chance of success not to do so. And this is a variation on the conjoined twins problem, which arose about 20 years ago on those famous judgments, where if you separate the 2 twins, one will die, but if you don't separate the twins, both will die. And the underlying principle is, it's not the NHS which is killing people, it's not decisions of doctors, it's the underlying pandemic, it's the virus. And the question is, how do you use limited resources so as to ameliorate the effect of the virus for as many people as efficiently as possible? So it is, I'm afraid, brutal utilitarianism, because anything else treats the patient in the queue worse than the patient on the ventilator. It's really tough for doctors, it's really difficult, but the frameworks in place, in my view, that I've seen, properly recognize the equality between different patients and don't give automatic priority to those at the front of the queue. These are really difficult issues, and if it's your relative who's on ITU, of course you wouldn't want them taken off. But if it's your relative that's waiting for the ICU bed and it's deteriorating fast and could recover, you'd have a different perspective. So that's a brief introduction to the problems of rationing. In principle, it's all lawful as long as it's done rationally. And those who have argued, and there have been a few who have argued, that it's somehow either a breach of the duty of care, or it's even a criminal offence, I think are wide of the mark, because they don't properly look at the allocation of resources across the system and focus unduly on the individual patient. That's all I'm going to say, and I'll pass over to Laura to talk about the much more technical subject of procurement. Laura.
Thank you, David. Thank you. That was extremely interesting and thought-provoking, so thank you for that. So turning to gloves, gowns and masks and the PPE judicial reviews. So as listeners on this webinar will be aware, the government has been taken to court over its procurement of PPE contracts. And during the next 20 minutes, I will give an overview of the background to the PPE judicial reviews, the key legal issues in those cases, and how those issues have been decided at the permission stage of the proceedings. I will say at the outset that I'm not directly involved in the PPE judicial reviews myself, and the extent of my knowledge is limited solely to information that is publicly available. The judicial reviews are ongoing, and some listeners may be involved in them on various sides. I will therefore intentionally limit the extent of my comments in some areas. And finally, for those of you who are in NHS commissioning roles, I will set out some practical tips to reflect on when procuring in urgent situations. So in terms of the background, well, we all remember all too well the unprecedented situation back in March 2020, when it became clear very quickly just how serious the pandemic really was, how it would impact on our lives and the daily impact it would have on medical and care home staff in terms of their own safety. There was no doubt that there was an unprecedented demand for PPE, not just in the UK, but of course globally, and indeed that in itself was affecting the certainty of supply. So to seek to ensure that there was sufficient supply, the government launched its Coronavirus Support from Business scheme on the 27th of March, which encouraged businesses supplying a range of products, including PPE, to register on an online portal to indicate how they might assist the government's response to the pandemic. Suppliers were asked to complete a form indicating the products they were offering, details of price, quantity, and technical certifications. They also had to give details of their businesses for the purposes of vetting. The government undertook some form of assessment to select suppliers with whom they wished to contract, and the details of the precise process followed and the form of assessment that the government used is part of the key issues in dispute in the judicial reviews. And it's important to note that the process that was followed was not an EU advertised process. One of the contracts that the government awarded, and the one that was referred to most prominently in the press, at least initially, was a £32 million contract to a company called PestFix. This attracted attention for several reasons, but mainly because the company allegedly did not have an established track record in supply of PPE to the NHS, although that's something in terms of their track record that PestFix disputes. That contract, entered into in April 2020, forms the basis of one of the judicial reviews, but there are two other similar judicial reviews which relate to PPE contracts awarded to other suppliers as well, including Ianda and Kleinborn. And those contracts, in fact, are a higher value even than the PestFix contract. And in all three judicial reviews, the claimants challenged the lawfulness of the contract awards. And whilst the issues in all three cases are very similar, the specific detail that I referred to in this talk relates predominantly to the PestFix contract. The claimants are seeking a declaration that the award of the contracts was unlawful and/or an order that the contracts are quashed, at least to the extent that they have not yet been performed. Now, judicial review is a two-stage process. And the first stage, known as the permission stage, is a filter which is designed to sift out claims or grounds which are not arguable. The court granted the claimants permission to continue with their claims just last week on the 17th of November. But at least in relation to the PestFix claim, permission was only granted on 2 out of their 5 grounds. So we will now look at the permission decision for the PestFix claim, which was made by Mrs. Justice Jefford, in more detail. And you can see here an overview of the legal issues and an indication of whether permission was granted or not. And I will now just run through those in some detail. So Mrs. Justice Jefford first decided 2 procedural issues, and remember that all of these are just being determined at the permission stage. So firstly, in terms of standing, one point of interest here is that the judicial reviews have not been brought by rival suppliers of PPE, but by the Good Law Project, which is a not-for-profit organisation that brings public interest litigation, and by Every Doctor, which is described as a doctor-led organisation that represents the interests of NHS frontline staff. So one of the issues that the court has to decide is whether the claimants, in this case, have sufficient standing. In other words, do they have sufficient interest to bring the claim? Now, as we know, there have been a number of high-profile cases that have been successfully brought by public interest groups against the government, and there's also a collection of cases in the procurement context that have been brought by individuals or groups as opposed to suppliers. Now, Mrs. Justice Jefford, in her permission decision of 17th of November, has determined that it is arguable that both claimants have standing to bring these claims. And slightly unusually, but due to the complexity of this particular question, she has deferred the issue of standing to be determined at the substantive hearing. So we will need to wait and see what the court actually decides on that point. In terms of limitation, Mrs. Justice Jefford also had to decide whether it was arguable that the claim had been brought in time, and she said that it was well arguable that it had. Now, the time limit in procurement cases and also in procurement-related judicial reviews is short. Claimants have to bring their claim within 30 days from when they knew or ought to have known that grounds to challenge had arisen. And the government argued here that time ran from the 27th of March, being the date that they launched the coronavirus support from business scheme. But Mrs. Justice Jefford said that that presupposes that the claim is a challenge to the nature of the scheme in itself and not to the procurement of a particular contract. And the claimants in this case would very much say that their claim is a challenge to specific contracts that were awarded. So turning to the substantive issues, the claimant's first substantive ground of challenge is that the government was not entitled to rely on Regulation 32(2)(c) of the Public Contracts Regulations in awarding the PP contracts without following an EU advertised procurement process. And Mrs. Justice Jefford has disagreed with the claimants on this point, and she has refused the claimant's permission to proceed on this particular ground. Now, Regulation 32(2)(c) allows contracting authorities, such as the government in this case, to award contracts without following an EU advertised procurement process in cases of extreme urgency. As such, it is an exception from the usual requirement to advertise and run a competitive process in line with EU rules. The precise wording of Regulation 32(2)(c) is that this exception may be used insofar as is strictly necessary, where for reasons of extreme urgency brought about by events unforeseeable by the contracting authority, the time limits for the open or restricted procedures or competitive procedures with negotiation cannot be complied with. And it's also the case that the circumstances invoked to justify the extreme urgency must not be attributable to the contracting authority itself. Now further, at the start of the pandemic, the Cabinet Office published emergency guidance in the form of Procurement Policy Note, or PPN 0120, in relation to the use of public procurement in response to the COVID-19 emergency. And that notice stated that in these exceptional circumstances, authorities may need to procure goods, services and works with extreme urgency. And the PPN sets out how this might apply specifically to the COVID-19 situation. So it states that authorities are permitted to do this using Regulation 32(2)(c) under the Public Contract Regulations. However, it makes very clear that the following requirements remain in place. So for the purchase to be strictly necessary, for there to be extreme urgency brought about by unforeseeable events, and for the circumstances to not be attributable to the contracting authority. And it sets out some situations in which it might be considered that certain events are attributable to the contracting authority, such as when they fail to plan or plan ahead sufficiently. So the claimants in the JRs argued that the need for PPE was foreseeable from February 2020, and therefore that it could not have been unforeseeable when the contract was placed in April. They also referred to the fact that the government had carried out a pandemic planning exercise in 2016. So essentially they were saying that the government should have been up and running and really ready for this, possibly as far back as 2016, but at least from February onwards this year. However, Mrs. Justice Jefford, in refusing permission on this point, said, and I paraphrase slightly, that the claimant's case identified a factual basis on which the need for PPE was foreseeable in February, but not the extent to which that need increased and market conditions radically changed, and or any basis on which a fully competitive tender process ought to have been commenced or completed so as to meet the need for PPE. And for the same reasons, Mrs. Justice Jefford considered that the claimant's argument that the circumstances giving rise to extreme urgency were attributable to the government was not arguable, so she refused permission on that first ground. In terms of the second ground, the claimant's second ground of challenge is that even where the extreme urgency exemption is relied upon, EU treaty principles, including transparency, equal treatment and proportionality, still apply, and that the procedure adopted by the government for awarding contracts in this case was not transparent. Now, Mrs. Justice Jefford agreed with the claimants, and she said that, or at least to the extent that she considered this point is arguable, and therefore she granted permission on this point. However, in forming that view, Mrs. Justice Jefford commented that the background to the award of the PPE contracts in this instance was the open invitation to businesses to offer to supply PPE before individual entities were approached to tender. And she said, in those circumstances, it seems to me arguable that the regulations and general principles relied on by the claimants require a degree of transparency as to the criteria by which offers would be assessed and potential tenderers selected, and that the procedure adopted was not sufficiently transparent. So this, to me, is one of the most interesting aspects of this case, certainly in terms of how it develops and how the court finally decides it. Mrs. Justice Jefford's permission decision on this point, i.e. the extent to which principles of transparency and proportionality still apply even when relying on the extreme urgency exemption, appears to be predicated on the fact that the government did run some kind of process. So they did seek offers. Now, in choosing to do so, did the government trigger an obligation to run that process in line with EU standards of transparency, for example, to publish their criteria? If so, what is the extent of those obligations in this context? What would be the position if the government had not invited offers, but had simply approached 1, 2 or 3 or a limited number of suppliers? Would the permission decision on this point have been any different? And it appears to me that it could well have been different. The claimant's third ground of challenge alleges that the government has given insufficient reasons for the placing of the contracts with the suppliers. In other words, that the government hasn't sufficiently explained why the suppliers in question were chosen over and above any others. And we have to remember here that the government received in the region of 24,000 offers for these contracts. The duty of transparency, to the extent it applies, does require the contracting authority to give reasons for its decision in such a manner to enable those affected to determine whether the decision is well-founded. And Mrs. Justice Jefford, in granting permission on this point, said that if the claimant's case as to transparency succeeds, it may well follow that the defendant has given insufficient reasons for the placing of the contract. So she therefore granted permission on this point as well. In terms of grounds 4 and 5, I can deal with these quite briefly. The claimant's fourth ground of challenge relates to the duration of the contract that was awarded. The claimants argue that a contract of 12 months duration was disproportionate. Mrs. Justice Jefford refused to grant permission on this ground on the basis that the claimants relied on factual matters that occurred post-contract, including whether or not the equipment had been delivered in a timely manner. And in any event, the judge noted that the contracted goods had already been supplied and this ground is now academic. However, this does raise an interesting point as to whether, when relying on the extreme urgency exemption in Regulation 32, one must limit the contract only to what is strictly necessary to meet the immediate need, which I think is to be implied by the wording of the regulation, and the extent to which that would then require a EU compliant process being run in tandem for any longer term needs. The claimant's fifth ground of challenge is the allegation that the award of the contract to PESFIX was irrational. And in refusing permission on this point, Mrs. Justice Jefford noted that PESFIX describes itself as a supplier of tools, chemicals and PPE, and with expertise in sourcing PPE for use in the pest control industry where hazardous chemicals are used. And in the judge's view, it was not irrational to place a contract with a company offering to source PPE and with such experience simply because it had no manufacturing capability itself. One of the issues was that in terms of its assets, PESFIX is a relatively small company. And the judge noted that relevant test certificates had been provided for the goods to be supplied. And the fact that there may have been some delays in distributing the PPE to the front line does not, in the judge's view, evidence deficiency or irrationality in the placing of the contract itself. So in summary, Mrs. Justice Jefford granted permission on 2 of the 5 grounds, being those relating to whether the award of the contracts was sufficiently transparent and whether adequate reasons for the award had been given. The claimants, as they are entitled to do, have requested an oral hearing to seek permission on the remaining 3 grounds on which permission was initially refused. That hearing will take place next week, and the final substantive hearing of the claims has been fixed for the 22nd of February and is expected to last 4 days. So just finally, in terms of tips for commissioning contracts in urgent situations. So I would refer listeners to PPN 0120 for a good overview of the options available to contracting authorities procuring in urgent situations. And whilst the PPN was published in response to COVID-19, it's important to note that it doesn't set out any COVID-specific exemptions, and all routes available or outlined in that PPN are those that are set out in our existing Public Contracts Regulations 2015. So in summary, the routes are direct award due to extreme urgency, which is the one that the government has relied on in awarding the PPE contracts. There's direct award due to absence of competition, where there is only one supplier, for example, who can meet your technical needs. That is used, but it's for obvious reasons, it's used fairly rarely. And again, there's quite stringent conditions governing when that can be used. One can also, in many situations, call off from existing framework agreements or dynamic purchasing systems, as long as they've been correctly established and as long as the purchasing entity is named as an entity that's entitled to call off under those. You can make a call for competition using a standard procedure, perhaps with accelerated timescales. And it's worth remembering that EU advertised processes can be run very quickly. So for example, under the accelerated open procedure, you can allow as little as 15 days between the dispatch of the contract notice and receipt of final tenders. In terms of final tips, if you are using a direct award procedure, remember that the conditions are interpreted restrictively and consider each situation on a case-by-case basis. As a rule of thumb, I would say always consider what are your alternatives, are there any reasonable alternatives, and really test the situation to see if there's an alternative route to a direct award. It's very important to keep a written audit trail and a written justification, and plan ahead and think about what your future needs are so that you're making procurement decisions in good time. And on that note, I will say thank you to you all, and I will hand over to Guy. Guy, I think you need to unmute yourself.
Thank you very much indeed, Laura. Mistake of the year. And thank you for your talk. My talk has a somewhat enigmatic title and potentially rather dry content. I think Laura's was drier than David's, and mine maybe a step further. But it's And it's not certainly not as immediately relevant as David and Laura's talks, but may perhaps have more relevance in any sort of post-COVID restructuring of NHS services. And the possibilities there must include a more vertically integrated model where it might be anticipated that GP services will be increasingly brought in-house in large trusts, as has already happened in Wales, or conglomerated into larger enterprises. It's also now clear that the NHS will have to continue to procure substantial services from private hospitals under block contracts post-COVID, if only to clear the waiting lists that are built up in other areas. The talk stems from a couple of recent cases that I've had, which have either directly or tangentially touched upon issues arising in connection with the value of GP's business or practice, and which have thrown up some interesting questions, which, though of vital interest to GPs, and particularly retiring GPs, I do think throw a somewhat wider light. As in many other areas nowadays, there has, since the formation of the NHS, been a public-private aspect to GP practices, which for the most part are funded out of public resources, but provided by the private enterprise of qualified doctors practicing as GPs. And as I'm sure a number of you will undoubtedly already know, in order to practice as a GP, you must first be a qualified doctor, then apply to join the GP register maintained by the GMC, which I think has been compulsory since 2006 and requires evidence of the requisite training to be a GP. Then once on the GP register, it's necessary to be accepted onto a performers list, which is effectively a list of approved contractors maintained by the relevant primary care organisation that commissions primary care in that area. This is intended to maintain quality and consistency of service and may apply criteria other than professional competence, such as language skills and adequate references. You then have to find either employment as a GP or join a GP practice. As to the latter, most GP practices are carried on as private law partnerships under relatively standard forms of partnership agreement, which will, among other things, provide for the retirement of the partners, the accession of new partners, and winding up, and which are generally governed by ordinary private law principles. The partnership, or the individual GP, will then contract with the commissioning body for the provision of services, which at least in England will generally either be a bespoke PMS, primary medical services contract, or more likely these days, a GMS, General Medical Services contract, which is a contract that's been nationally negotiated and as to which there are detailed directions issued by the Department of Health as to what it must cover. And these determine what's to be paid under the contract in respect to medical services, based on, for instance, the number of patients or specific services provided, and for additional sums, for instance, to cover premises costs. The latter are often important because GPs have traditionally provided services from their own premises. And there are complex and somewhat badly drafted directions regulating the sums that will be paid by the commissioning body for the GP's use of their own premises as a surgery and for the purchase and development of new premises. And it's usual, for reasons that will become apparent, that much of the value of a GP's practice will be tied up in the value of their premises. It also appears that there have been incidents where commissioning bodies appear to have miscalculated or overpaid sums in relation to premises costs. And an example is a case which I think David Locke has been involved in, or was involved in, NHS Commissioning Board and Sivolsky, 2015, EWHC 3141, and again in the Court of Appeal, 2017, EWCA Civ 1389. In that case, the overpayments have been made under a bespoke PMS contract, and as the commissioning body had on the true construction of the agreement agreed to pay the sums, they could not be recovered by way of restitution. The situation might be different in relation to a GMS contract, however, under which the directions on the face of it require that only sums properly due are payable. And this can be of particular importance in relation to dealings between partners, because on a retirement, it's the value of the premises which will principally determine the amount to be paid to the outgoing partner. The value of the premises are often effectively determined by what the relevant directions refer to as the current market rent. This is a sum determined by the district valuer as the notional market rent for the property. But as there's no market for the premises, it is in reality a matter of negotiation with the district valuer. And if the commissioning board is overpaying in relation to premises costs, then this may be argued by an outgoing partner to have a knock-on effect on the value of the premises, because the capital value of the premises is calculated backwards as a multiplier of the income they generate, which is what's been agreed with the district valuer. Yes. And the reason that the value of premises is key is that under the NHS legislation, there's a statutory bar on the sale of the goodwill of a practice. That's under section 259 of the Consolidated NHSA Act, NHS Act 2006. It's unlawful to sell the goodwill of an NHS medical practice, and goodwill is defined very broadly as any part of goodwill, and in relation to a person who's practicing in partnership means his share of the goodwill of the partnership practice. So there is no guidance at that stage under the Act as to what goodwill is. Schedule 21 further makes it a criminal offence to either sell or buy the goodwill of a medical practice. And there are further detailed provisions preventing the realisation of goodwill. There is a provision in Schedule 21 of the Act that any person proposing to be a party to a transaction which he or she considers might amount to a sale of goodwill can ask the Secretary of State for a certificate, which, if all material circumstances are disclosed and are not misrepresented, will be a defence to criminal proceedings. But that does not, however, determine as between the parties whether the sums paid are in fact lawful as a matter of private law, which may depend on the true construction of the relevant directions. And this can lead to an intricate dance between the valuation provisions in the partnership deed, the meaning of goodwill, and how to deal with any question as to whether the sums in fact being paid in relation to premises are being lawfully paid. Some of these issues arose in a case Deacon and Yassin, which effectively decided that any sums properly payable under the relevant directions could not by definition be regarded as goodwill, but by inference, any sums which could not be lawfully paid under the premises directions, but were in fact being paid by the commissioning body, should be disregarded in the valuation of the premises. So that brings us back to what is goodwill, and not only as a matter of domestic law, but also under the ECHR jurisprudence in relation to Article 1, Protocol 1. This protects against the unreasonable and disproportionate interference by public authorities with a person's assets, I think is how it's best described. That's effectively anything in the nature of property, something separate from the person, which a person has and can be taken away or interfered with by public authorities. Again, I'm currently dealing with a case on A1P1 in the context of contracts dependent on the payment of feed-in tariffs for small-scale solar panel installations, which doesn't have much to do with doctors. And indeed, I was in the Court of Appeal earlier this month, though I would not recommend watching the video for the purposes of gripping entertainment. But one of the leading cases we were dealing with there brings us back to GPs, because it's the case of Queen on the reference to Malik against Waltham Forest and NHS Primary Care Trust. In that case, Dr. Malik was a GP who was unlawfully suspended from from the performers list. In other words, the approved list of contractors, which prevented him from practicing as an NHS doctor. He claimed that his inclusion on the list was an A1P1 possession, and he was entitled to damages under the Human Rights Act. He won at first instance on the basis that his inclusion on the list was in the nature of a license, which was an A1P1 possession. That was, however, overturned on appeal. The reasoning in the case is not altogether easy to follow. Indeed, the English jurisprudence in this area has generally become very difficult to untangle, and I'm not going to attempt to do so in 20 minutes. It is, however, my view that the case does not rule out doctors who've been unlawfully struck off the performers list from potentially having a claim in other circumstances. But before turning to the case, I've mentioned goodwill in passing, and I'll now say something about legitimate expectation, which also forms part of the title to my talk, and then try and bring it all together in this context. It's not an easy area, so bear with me. And this is very much an overview, and some of the propositions I'm putting forward may be to a good degree controversial. Abuse of process is the core concept in the public law doctrine of legitimate expectation. It is also, for obvious reasons, a core concept under the European Convention on Human Rights. The principles of legitimate expectation in common law are closely analogous to private law estoppel, and see in particular Mr. Justice Dyson, as he then was in PowerGen. Since the seminal decision in, and I'm not sure whether I'm right or David is right, Coughlin or Coughlin, it's been a settled matter of domestic law that a legitimate expectation can be substantive as well as procedural. In other words, you can have a legitimate expectation of something substantive and valuable. And the principal difference between the doctrine of legitimate expectation and estoppel is that estoppel is purely concerned to ensure that private individuals act in a conscionable manner towards each other, whereas the public conscience, when one's dealing with the public conscience, one often has to balance matters of the public interest, unless there's really none, with the private expectations of the individuals involved. And the public conscience is only effective if the public body's conduct can be characterized as an abuse of power, or as Lord Steyne put it in Anni Frieva, an affront to the public conscience. As, however, with private law estoppels, legitimate expectations may arise as a result of either an unequivocal representation or conduct such as standing by while another changes their position, or a conventional course of conduct. But they're not necessarily required to be forced to establish private law principles. And the case I refer to for those propositions is a tax case, ex parte Unilever. And that also makes clear that the categories of abuse of power are not closed, just as the categories of unconscionable conduct of private law, recognized by courts of equity, are not closed. But where the public interest has to be balanced against a private interest, then if the public interest is to be preferred, it must be a proportionate response. And that's the now very well-established and often cited judgment of Lord Justice Laws in Nadaraja. Now, there's a very similar approach in the European jurisprudence on A1P1, and see in particular Pine Valley Developments and Stretch. And applying that jurisprudence in relation to A1P1, the European jurisprudence has recognized that where a professional man has spent time and effort training, qualifying, and building up the clientele of a practice, then he has a legitimate expectation of continuing to earn an income in the future. In other words, he has goodwill, which has been given in this context an autonomous ECHR meaning, which is an A1P1 possession. And an example that I would refer to is case of Van Maal and Netherlands. That was an accountant, but there are other cases on doctors. He had practiced for many years as part of an unregulated profession, but there was then required to be certified to continue in practice. His application for certification was refused, and he claimed an interference with his A1P1 rights. It was held there had been such an interference, albeit on the facts of the case, it was justified. And on a careful reading of the case, it's quite clear that the court was concerned with his personal opportunity to continue to earn an income in the future from his professional expertise, rather than his ability to sell his practice, because he'd obviously spent many years investing time and energy to build it up. Returning to Malik, it's necessary to understand that Dr. Malik lost because his mere inclusion on the performers list was held not to be an asset in itself. And that's particularly clear from the comments made by Lord Bingham in the Countryside Alliance case. In the, I'm not sure that's the right reference because it was in the House of Lords, which is the case concerning interference with people's livelihoods by the banning of hunting with dogs. And Lord Bingham thought Malik was rightly decided because as he analysed the case, the Court of Appeal held that the inclusion of Dr. Malik's name on a list of those qualified to work locally for the NHS was in effect a licence to render services to the public, and being non-transferable and non-marketable was not a possession for the purposes of Article 1. And that's the essence of the decision. There are some licences, such as perhaps topically fishing licences, which could be transmitted for value and are assets in their own right. A mere permissional licence, however, does not confer any valuable benefit. All it may do is permit another asset to be exploited for value. And the European jurisprudence shows that if a licence to carry on a certain business is withdrawn in accordance with its terms, then there's no legitimate expectation that the business will continue. But if a person has a legitimate expectation that the licence will continue and it's unlawfully withdrawn, then there might well be a breach of A1P1 rights. The point that was made in Malik was that if you were to look for an A1P1 possession that might have been interfered with, was not the inclusion in the performance list, but the contract Dr. Malik had with the commissioning body. And there was no claim in respect of the contract, as he was continued to be paid under it. I think he would continue to be paid 90%, but in effect, he hadn't claimed that it had been interfered with. If, however, Dr. Malik's contract, in which he'd earned an income from an established patient list, had been terminated because he'd been unlawfully removed from the performance list, in circumstances where he had a legitimate expectation that he would remain on it, then the outcome might have been different. And that's possibly both under ECHR jurisprudence and also under domestic law. And that is what I wish to say on the subject this afternoon. So back to you, David.
Thank you very much, Guy. I think if you just stop sharing your screen, then we'll be able to go.
If I can find the right window, I will do that.
Thank you very much. Great. And before we move very quickly on to questions, if I just invite those attending to put any questions you may have in the Q&A box at the bottom, then I'll happily pass those on to our speakers. If I may, I will perhaps start with just one of my own to get things going. It occurs to me that certainly in the present time, urgency of decision making from executive bodies, and indeed from the NHS in particular, is going to be at the forefront of everybody's mind. And I wonder to what extent the powers of the court are able to act effectively whilst that urgency is in mind. In essence, I think I'm asking the panelists for their views as to whether the courts can provide an effective mechanism when there's a good chance in current circumstances the horse may already have bolted, as it were. I think that's certainly something that comes up in terms of judicial review claims, either from potentially from a procurement perspective. I mean, we've heard that our case is going to be coming along in February, and we're a long way down the line in terms of provision of PPE. It may well be a point that arises in terms of rationing. If somebody's removed from a bed, is there a good chance that the judicial review is going to come too late? So if I go with that highlight issue, what are the thoughts from the panel in terms of urgency and decision making?
Well, if I can come in first, David, the answer is the judicial review is a very flexible remedy, and it's often surprising how quickly the JR court is able to move. Having said that, there are two caveats. First of all, there's considerable latitude given to the public bodies in taking really difficult decisions, particularly rationing decisions. I think you'd have to have a pretty egregious decision to be able to get a High Court judge to interfere with what is essentially a clinical rationing decision. Secondly, of course, there is the practical problem of finding a lawyer with this expertise, which is not, enormously widely held, and being able to move and make an application quickly. So there are practical problems for anyone wishing to challenge, but with the right case in the right argument, as opposed to just a sense of injustice not backed up by a good legal argument, the courts are able to move extremely quickly.
I suppose you could be applying for something like a mandatory order, an interim mandatory order, if you were that strongly about it. I suppose, David, is that the direction you're thinking, or? Well,
I mean, I've seen all sorts of orders, and indeed I've granted all sorts of orders when I'm sitting. It all depends on the circumstances and the strength of the case, but one can never link the extent to which people feel a sense of injustice about a decision does not necessarily have any relationship to the legal merit underlying the complaint. So essentially, you need a really good legal basis for your complaint and urgency. And if you've got that, you may well obtain interim relief from the court that's at least appropriate to try and hold the ring until the public body has got an opportunity of putting in a full response.
And what about in a procurement context, Laura?
Yeah, so in a procurement context, I mean, certainly for suppliers who are bringing challenges under the public contracts regulations, which could include a challenge to a direct award procedure, if they do find out about that an award is imminent and they do get their claim form in before the contract has been signed, then there is an automatic suspension. So if you like, an automatic injunction on the contracting authority going ahead. Now the contracting authority can then apply for that to be lifted, and the American cyanamide principles in essence do apply. But that is, I mean, it is for suppliers, that is quite an effective means of getting immediate redress without actually having to go through the process of applying for an initial injunction. Now, the difficulty here when direct awards are being made, and I think it's fair to say that in the, say, for example, in the pest fix scenario, that knowledge about that particular contract didn't arise until after it was actually awarded. So by that point, any prospect of an injunction, whether an automatic one or otherwise, had passed. So perhaps that's the sort of difficulty in that kind of context. But it's an interesting point that you raised, David, about how effective the court process actually is in that, you know, extreme urgency situation. And I think back to the, you know, the useful paper that you put in recently in terms of the you know, review of the whole judicial review paper, and as you rightly said in that, you know, the very fact that we have a judicial review process, in essence, in part it encourages public bodies to think carefully and go through certain processes in terms of their decision making, whether that needs to be in a procurement context a fully EU run procurement process, or whether indeed, you know, there really are grounds, as there really sometimes are, for following direct award procedures.
Thanks, Laura. I should say, anybody who's not aware, the SWALA put in a response to the independent review of administrative law recently, and if you wanted to see that, I understand it is available on our website. But thanks for that, Laura. That's really useful. Guy, I don't know if you had any observations on that point.
I wasn't going to make any observations about how you can act effectively and urgently, but I was going to make some observations about how it can act in retrospect. Because if sums have been paid unlawfully to private companies, then potentially they can be recovered by way of restitution at a future date without any of the urgent time limits for judicial review and the like. Now, I was involved in a case that went to the Court of Appeal where we tried to do that in a procurement case, CTE in Cornwall County Council, and we won at first instance. We argued that our decision to enter into a contract was ultra vires, and therefore there wasn't actually a contract, so we got the money back. We could have the money back. Unfortunately, the Court of Appeal took a more sort of ostensible authority type approach and said even though we were a public authority and we may not have had power to enter into the contract, and query, I'm not sure we explored how much the contracting party should have suspected we didn't have power to enter into the contract. We couldn't have the money back, and the Supreme Court wouldn't let us take it any further on the facts of that case. So it's a very interesting area, and it isn't straightforward, but and I suppose from a JR point of view, people might think that if contracts have been entered into unlawfully, the government ought to be considering getting money back. So I think that's what I would add.
I would just add, David, I've had a case this week where we're adjourned for judgment on two public bodies arguing that a breach of public law gave rise to an issue on unjust enrichment. So watch this space. I think there will be a judgment in a few weeks' time that will look precisely at the issue Guy has. It is very, very complex.
Yeah, hot off the press. That's excellent. So everybody be waiting for that one, I'm sure. Perhaps I'll abuse my position and ask a second question then. And in essence, an interesting point that came certainly for me out of Laura's talk, and I think it has wider application, was the use of the word transparency. And I'd be interested to know the panelist views about the extent to which the NHS in particular needs to be transparent about its decisions, and then perhaps maybe some thoughts about the wider public law context. So is transparency becoming more of a JR issue? I certainly looked at the judgments such as Miller, for example, where there was some criticism of the government for potentially not being as transparent as it could be about its prorogation decision. But what do we think about the issue of transparency in that narrow and perhaps larger context?
Shall I start off perhaps from a procurement context? I mean, certainly in terms of the EU standard of transparency, which is the principle that we have in procurement law, I mean, that's a relatively high standard, I would say. So in the procurement context, it equates to publishing criteria and publishing methodology for assessing tenderers to the extent that could impact on the way they prepare their bids, publishing decisions and the reasons for those decisions in a manner that enables those affected to properly understand the nature of the decision and to defend their rights if necessary. To me, it's a far higher standard than, say, rationality as it applies in judicial review. I think for me, as I said, one of the really interesting points arising out of the PPE JRs is that where you do have a genuine urgency situation, as the court recognised in the award of PPE contracts, certainly at the start of the pandemic, and in such a situation where they were entitled in principle to use a direct award regime. So, to what extent does that entail just going to a handful of suppliers? You don't have to run a competitive process under that extreme urgency exemption. But the interesting point that if you do choose to do that, to what extent do those transparency principles then bite on whatever process that you are doing? And I think it is interesting actually in the PestFix judicial review that they were granted permission on transparency points, but actually refused permission on irrationality points, which I think is interesting in itself, because as I say, I see rationality as a sort of lower standard.
So for you, Laura, then it's more of an EU context as opposed to a domestic context, or is that being too simplistic?
No, I think that's right. I see transparency as coming from the EU sphere and being at that imposing that higher standard than I think, in my view, that we have under UK public law. But interested to see what David and Guy think about that.
Guy, you go next.
Well, there'll be a duty of candour in relation to these matters, just as there is in any other public law scenario. And I dare say if the court is suspicious, as it is becoming increasingly so nowadays, that duty of candour hasn't been fully met, then it has ample resources to order further disclosure to see whether there are any there are proper reasons for what was done and whether the decisions were taken in good faith. But I'm not sure I can say very much more than that.
I just say that the duties on NHS trusts, who are the providers of services under Section 242 of the NHS Act, and the duties on CCGs under Section 14Z2 of the NHS Act, both emphasise the need to involve the public. And there's a strong element of transparency because you can't involve the public in decision-making unless you do your decision-making in a transparent manner. And all the guidance that sits behind those provisions emphasises the importance of transparency. Having said that, trying to litigate them is fantastically difficult because the NHS tends to take decisions first and then consult afterwards. Judges are quite often reluctant to interfere with decision-making processes, however unpopular they may be, on the grounds of a lack of transparency, because quite often, by the time the decision has been made, there is quite a volume of material in the public domain justifying the decision. So going back to an earlier stage and saying they weren't transparent at an earlier stage is quite difficult. But I've no doubt that the JR that I mentioned about the lack of policy guidance on rationing will be on the basis of transparency. It will be very interesting to see where that JR goes, because essentially the way that public bodies make decisions that affect the public and are made with taxes paid by the public. So they're made on behalf of the public with the public's money, and the public has the right to know how those decisions are made. And that's the principle that lies behind greater transparency.
Thanks very much. That's really useful, David. And thank you, Laura and Guy. And unless any of you have any questions you'd like to perhaps ask each other, and overshadow my role as chair, I'm probably going to bring things to an end, especially with the mind that David's been mediating all day and is probably quite tired.
Thank you very much. It's been a pleasure. Thank you for inviting me.
And so if I just take this point to say thank you, firstly, to all of our speakers, Guy, Laura, David, wonderful talks, and I'm sure those attendees who are with us, and indeed those who are going to be downloading afterwards, are very grateful. In particular, I think thank you to you, David, for joining us. Guy, Laura and I are committee members of SWALA, and so we extend our thanks to you for joining us and giving us your thoughts.
No, it's been a real privilege. Thank you very much indeed.
I also just very quickly like to thank the wonderful people at St John's Chambers. That you've done a great job setting this all up for us, and we are very grateful for your time and patience with many of us in terms of learning how to actually use these facilities. And finally, thank you all to all of you attendees who hopefully have found this very, very useful seminar. And I reiterate, please do follow us on Twitter. Please do reply to our links with the SWALA survey and the feedback survey. And please now go on and enjoy the rest of your evening. So thank you very much to all of you.